People versus Jurgins, number 178. Counsel, you want any rebuttal time?
2 minutes, Your Honor.
Go ahead.
May it please the Court, Lisa Packard on behalf of Mark Jurgins. Your Honors, Mark Jurgins' sentence is unlawful as revealed by a strict equivalency analysis of the D.C. robbery statute. In short, there is no way to charge robbery under the D.C. statute without encompassing misdemeanor-level conduct.
Go ahead, I'm sorry.
Is there no way, or should there be a hearing as to determine exactly the facts underlying his plea?
There is no way when we look at it on its face, and that's because the operative act elements always encompass misdemeanor-level conduct.
Right, but could we have a hearing and say, did you pick the pocket or did you put a knife to the guy's throat? I mean, could we use...
Under this Court's strict equivalency test, it's irrelevant because we don't look to the underlying facts. We look to whether or not the operative...
If it's evident on its face, that's the end of the story?
That's the end of the analysis there. And that's exactly what we have going on here. And actually, the strict equivalency test...
How is it evident on its face?
Because neither of the operative act elements listed in the statute require force or the threatened use of immediate force. And
if the statute were turned around, if the statute was a felony and not necessarily your client, but the next one said, sure, it says felony, but I didn't, all I did was pick a pocket. I didn't use a knife. I didn't did anything violent. Would we be saying, we're really sorry, but you're a felon just as if you did use a knife because that's the strict application of the statute? That wouldn't be fair, it seems to me.
I don't know how a defendant would be convicted under a foreign statute for pickpocketing unless that statute did encompass non-felony level conduct in New York. So, and that's exactly what's going on here. The whoever by force or violence language includes within it pickpocketing. That's grand larceny in the fourth degree here in New York, the attempt of which is a misdemeanor.
Do we have to look at D.C. case law, D.C. judicial determinations to figure out whether or not you're correct when you say, because this is the dispute with your adversary, when you say the statute is on strict equivalence, you can just look at its face because, as you say, the operative acts don't require force.
That's right.
Right? How do I know that? How do I know by reading the statute we're talking about acts, or the way you do something, or something else?
So we do look to the D.C. case law, and actually this Court...
So I can't just look at the statutes, correct?
Right. So we look at the statutes, and sometimes, actually, sometimes...
in this case, can I just look at that statute and know, or do I have to go to D.C. case law to figure this out?
In this case, you have to go to D.C. case law to figure out that force or violence doesn't actually require force or violence. It's sort of a counterintuitive statute, and the D.C. case law is pretty clear, showing us that D.C. expanded the common law definition of robbery to include pickpocketing, which is punishable as a misdemeanor as jostling or the attempt of grand larceny in the fourth degree.
That's the stealth or sneakily taking or whatever, but what about the putting in fear section?
That also doesn't require force or the threatened immediate use of force. And so on its face...
You know what I wondered about is it seems like Yusuf, which is a court of appeals case, I'm not sure, this court of appeals case, seems to provide the basis for the exception that for looking at the foreign accusatory instrument, and I'm having a difficult time seeing how you would distinguish the court's application of that. Are you familiar with it?
With this court's case in Yusuf? Yes.
Y-U-S-F, okay. I hate tricking people, and asking them if they're familiar.
That involved the North Carolina statute, is that right?
I'm not sure about that, but it seems to be on all fours with this case in that it requires, it allows the court to scrutinize the accusatory instrument of forest jurisdiction here, that would be D.C., if the statute renders not one act but several acts criminal. And that's what I would say that if that seems to be the case with the D.C. statute, I think you're right about that. So why can't the court look directly at the D.C. accusatory instrument? Forget about a hearing, but the accusatory instrument.
Okay, so I would actually disagree that it's like Yusuf. It's actually schematically more like Ola or Muniz, where there's an operative element that must be alleged in the indictment no matter what in order to charge a defendant that will always include possibly felony-level conduct, but also misdemeanor-level conduct.
How would you characterize the D.C. statute? Is this a felony and a misdemeanor?
it encompasses both felony-level conduct and misdemeanor-level conduct, however it's charged in D.C. Of course, we do have the accusatory instrument here in this record by way of the 440-20 motion, and it alleges the whoever by force or violence language, which includes pickpocketing.
You don't think this is an OLA exception?
No, we do not think it's an OLA exception because both of the operative act elements, however you interpret the statute, include both felony level and misdemeanor level conduct. So the analysis ends there. And actually, the exception is rarely invoked. The strict equivalency test commands or directs that usually the inquiry is limited to a comparison of the operative elements as they're defined in the relevant statutes. And so the analysis ends there, and the preservation requirement falls away, and we need not go any further than that.
Does the D.C., you said earlier that we don't necessarily look to the statute alone. We could look at, or we need to look at D.C. Decisions, the law from D.C. So are there decisions that interpret the statute differently, or are they consistent in interpreting the statute the way that you claim the statute should be interpreted?
They're largely consistent. It's a bizarre statute in that the phrase force or violence doesn't actually require force or violence. The case that was recently provided by my adversary to the court does contemplate that robberies by putting in fear might be a separate way of committing robbery, but again, that kind of robbery does not require force or the threatened use of force. So under any iteration or interpretation of the statute, and if we look to U.S. v. Turner, which is sort of the seminal case on the issue in D.C., that interprets the statute as all of the language coming after whoever force or violence, modifying that language to include pickpocketing. So it's fairly clear from the case law that however the statute is written, pickpocketing, stealthy seizures, or snatchings are always included. And so for that reason, on its face, it fails. And Mr. Jurgins, having been sentenced on the basis of this D.C. statute, his sentence is unlawful, and it must be vacated, and there should be a remand so that he can be resentenced lawfully.
We talk about whether or not I can bring this on the 440-20.
Pardon me?
We talk about the 440-20 issue.
Sure.
Please.
So
Can he raise this claim through a 440-20?
absolutely. It's the appropriate mechanism for challenging an unlawful sentence. He did so before the direct appeal. It was consolidated with the direct appeal and brought properly before this court. And in challenging his sentence, he made the very same arguments that he's making here. This court has contemplated that 440-20 is the appropriate mechanism for challenging unlawful predicates, namely in People v. Laughlin. Sam's, I think, was just raised on direct appeal because the chronology requirement was just apparent from the face of the record. Laughlin addressed a defendant who was trying to challenge his second felony offender adjudication from a previous case, and this court said that his failure to do so on direct appeal or by post-judgment motion, appropriate post-judgment motion, barred him from making that claim in that subsequent proceeding.
So
but
if we remand, can the people file a new predicate statement
yes,
based on another crime?
Yes, they can, Your Honor. If there are proper predicates to be filed, they can submit a statement with those predicates, and at that time, those issues can be litigated. They can swap in whatever predicates exist at that time. That's correct, Your Honor. And that would be the appropriate procedure.
The appellate division raised an issue of preservation. What did you think of that?
Unlawful sentences are just not subject to the preservation requirement. It's rooted in a policy rationale that is well established and pronounced by this court. Unlawful sentences cannot stand so long as the error is readily discernible from the trial record. And since the strict equivalency test, generally speaking, does confine us to the trial record, as it does here, there's simply no basis for not reviewing this claim. And Sam's addresses this as well. So long as the error is apparent to the court, preservation is – it's a narrow exception to the preservation requirement.
If we felt that preservation was required, could we consider the 440 motion as preserving the issue?
Absolutely. And because of this court's case in People v. Laughlin, again, because it addresses the fact that it's appropriately brought on direct appeal or by post-judgment motion in that case. So you know, and being part of the consolidated judgment, which is now before this Court, it's a question of law regarding the legality of the sentence, which is properly before this Court.
Okay, anything else, counsel?
Unless Your Honors have any further questions.
Thank you, counsel. Counsel?
May it please the Court, Catherine Reno for the Office of the Bronx District Attorney. Defendant here waived his claim that his prior conviction.
Even if it's evident on the face?
It isn't evident on the face of the record
Why isn't it
here.
evident on the face?
Well, first of all, this is a very complex analysis. If only just by looking at the briefs, it's clear that there are many steps that courts have to go through in order to determine whether a predicate is the equivalent of a New York felony.
Well, isn't it just you're going to look at the statute, and if you need to look at the D.C. case law, you do so?
Well,
I mean, it may be complex analysis, but that's all you have to do, right?
That is, but this court has only found an exception to the preservation requirement when the illegality is readily discernible from the face of the record, such as in Sam's, where there was an undisputed sequentiality issue, or in Santiago, where the court didn't need to look at anything at all outside the record. The parties agreed that the equivalent New York statute was manslaughter in the second degree. And the defendant's date of birth and the date of his prior Pennsylvania conviction were right there on the record in the pre-sentence report.
Departments usually look at, when necessary, at case law?
I'm sorry, I didn't.
The appellate departments usually look at case law?
It has been done, but that only highlights why this isn't evident from the face of the record when this court has to not only look at foreign statutes, potentially foreign accusatory instruments, and then foreign case law. The case Williams v. U.S., which the D.C. Court of Appeals decided only 6 months ago, makes clear that this could go on forever.
If we agree with you, does that mean that, let's assume for one moment that it's not equivalent, but let's assume you're correct, that this is waived, that he's subject to an unlawful sentence that he can never challenge?
No. First of all, his sentence is lawful. 11 years is a completely legal sentence and a lenient sentence for a first or second felony offender. Beyond that, even though both courts found that this claim was unpreserved and waived, they both examined the merits and the alternative. So it wasn't as if defendant was shut out from his claim being heard. Both of these courts looked into the claim.
I have a practical question for you. You indicated that the defendant had a long felony record or an extensive one. Why pick this particular felony for the predicate? Why not? Did he not have some New York felony that you could have used?
He did not have any New York felonies.
New York felonies.
They were all in Washington, D.C. So he had committed this crime twice in Washington, D.C., but he didn't have any New York felonies that could have been chosen.
But he had did he have a D.C. felony that was clearly a felony?
He has escaped from prison, felony cocaine possession, and then these two.
So if he gets set back, you have a felony you can swap in?
Potentially. I can't say for certain now. Obviously, more research would have to be done, but potentially he does have a myriad of other felonies that could be chosen.
But this was enhanced to 25 years, wasn't it?
That's correct. And then the appellate division, in the interest of justice, reduced that to 15 years, which, again, is a perfectly legal sentence for a first or second felony offender.
But his record will stay as a second felony offender, right?
That is correct. If Your Honors have no further questions.
Thank you, counsel. Counsel rebuttal?
Just a couple things, Your Honor. There's no waiver of an unlawful sentence by silence. That's addressed directly in
But
Sam's.
isn't 15 years a lawful sentence?
Pardon me?
Isn't the 15 years a lawful sentence?
It's the predicate adjudication that's unlawful. And so the violation of the penal law
It's
scheme.
the status.
Right, exactly. The 7006 penal law scheme, any violation of, any sentence imposed in violation of those statutory mandates.
Didn't we require preservation in Smith, where we were dealing with a federal? Yeah.
So Smith was, it's unclear what's happening from that two-sentence memorandum opinion exactly, but this Court's decisions in both Sam's and Santiago limit and explain what's really going on there. And the concern that emerges from all of these cases is that We're looking for a record that makes it readily discernible that the sentence is unlawful. So long as the record reveals that, I mean, Santiago disposes of the notion that there's a blanket rule of preservation for foreign predicates. And so long as the illegality is apparent from the face of the record, then, you know, there's no bar to preservation. Waiver, just want to note, too, waiver must be done by some knowing colloquy on the record. There has to be some showing that the defendant was aware that he was giving up his right to be sentenced as provided by law.
Okay, counsel. Thank you both. Appreciate it.